Thank you. Again, welcome to all. This time we're on record in Black Canyon Irrigation versus State of Idaho. And on behalf of the appellant, Black Canyon, Andrew Waldera will argue. On behalf of the respondent, Michael Orr will argue the first 20 minutes. Michael Lawrence will argue the next 10 minutes. Christopher Meyer and Darrell Early will appear only. Are there any preliminary matters? Very well. May proceed, sir.
Thank you, Chief Justice Burdick, members of the court. My name is Andrew J. Waldera of Sawtooth Law Offices in Boise, here on behalf of Appellant Black Canyon Irrigation District. I'm here today for one simple reason: to defend and secure the water rights that my clients' livelihoods depend upon, either by defending the existing storage rights for Cascade and Deadwood reservoirs, or in the alternative by obtaining judicial recognition through the existing SRBA lay claims of the constitutional method water rights perfected by the pre-1971 diversion and use of flood control releases. Unfortunately, while Special Master Booth did the former, the presiding judge did neither. And I'm going to go a little bit off script for a moment, Justice Brody and Justice Burdick, to get to a couple of the questions you posed in the first appeal. Obviously, these appeals are related. One of your questions, Justice Burdick, was why no challenge in 1993 when the computerized accounting program went live? The accounting program came in and tracked water, but as a practical matter, it didn't change the administration of those water rights. The experience of the water users on the ground continued to be full reservoirs and full storage right entitlements. The state's there is no water right, or that this is permissive storage as a matter of administrative whim and policy, didn't fully crystallize until roughly 2009 in the Basin 1 proceedings in the SRBA, the refill remark, and then further crystallizing in the 2012 Basin-wide Issue 17 proceedings. So tracking water as an accounting measure, that's fine. But this there is no water right theory is a serious problem. Justice Brody, you are asking whether the U.S. could or could not have, in good faith, filed the late claims during the pendency of the paid adjudication. I grant you that on the face of the late claims, the priority date claimed is 1965. The fact of the matter is that the U.S. could not have, in good faith, filed those late claims because of the change in circumstances you've heard in the first appeal, and I will detail in greater detail later on in this argument. As a practical matter, the Bureau had nowhere to put more water. The physical capacity aggregate of the reservoirs is 863,000 acre-feet. That's what they claim. That's what was licensed. That's what they claimed in the paid adjudication. That's what they exited the paid adjudication with. Further, as a practical matter, there was nowhere else to use the water. The original licenses, claims, and then subsequent decrees were decreed against the backdrop of irrigating 215,000 claimed acres in the lower Payette Valley. There was no increased breakout of new ground. Justice Burdick, you asked an enlargement-based question. I think you received the answer to your satisfaction. But the fact of the matter is I agree with your instinct. It is absurd for me to be standing here before you to say we need 1.3 million acre-feet to net 863,000 acre-feet of beneficial use water. If that's the case, if that's going to be the new change in law that this court is going to ratify, then I guess we do need 1.3 million acre-feet to secure 863,000 acre-feet of beneficial use water. But that beneficial use and the acres on which it's used is not changing. It is not an enlargement in the sense that there is going to be more consumptive use. There is not going to be more consumptive use. Finally, Justice Brody, you asked a couple of questions related to the record. Where might you find references to what are the claimed acres, what are the claimed amounts of water at issue in this case, who are some of the water users, for example. You can find that in record pages 719 and 720. Those are the original licenses for Cascade and Deadwood reservoirs that claim in aggregate 863,000 acre-feet of use from water. Excuse me, not claim, excuse me, those are the licenses. Those licenses grant that amount of water. And further describe the 215,000 aggregate acres on which these water rights are used. You can also go to the second affidavit of Michael Orr, which is record page 434 and several following pages, specifically Exhibit 5, which were the payette claims, which again asked for the same amount of water for the same acres. You can go to Exhibit 6, which are excerpts of volumes 1 and 2, the proposed finding of water rights in the payette decree, where the department confirmed through its own independent investigations of water use and diversion in the system, specifically including the diversion and use of high flood flows, confirming the same 863,000 acre-feet of water in use on the lands. And you can go to Exhibit 10 in that second Orr affidavit, which again are the 1942 and 1967, if memory serves, licenses. And finally, to give you a feel for what are the irrigation entities implicated in this matter, you can go to record page 1818, which is a mailing list from 1995 when the rule curves were adjusted based on the NEPA process, setting aside conservation pool and Cascade Reservoir. For your purposes, the two irrigation entities who stand to be harmed the most, first and foremost is Black Canyon. It is the largest storage water holder and user. And then second would be Emmett Irrigation District. Emmett Irrigation District primarily has storage in Deadwood Reservoir, whereas Black Canyon is primarily reliant on Cascade. But that certificate of mailing will also point you in the direction of the other irrigation entities involved in the valley. Not all of them have storage rights. Some of them are just natural flow. But again, the two entities that do and very much depend on the storage water are Black Canyon and Emmett Irrigation District. And finally, Justice Brody, you asked the question of what changed. If the accounting program is not a regulation, law, rule, what have you, and it doesn't have the ability to do anything different, I agree with you, and the state agrees with you, and Suez agrees with you, except for the practical fact that you're going to hear in January the legal theories that support the accounting program, which are the legal theories that we rail against in this case. And Special Master Booth was right on your wavelength. If you look at the brief for Respondent Black Canyon Irrigation District in the U.S. Appeal at page 2, footnote 1, Special Master Booth said, as a de jure proposition, counsel for the state is absolutely correct. And I'm paraphrasing now, the idea that the accounting program cannot define, create, alter, or affect water rights. But Special Master Booth continued. And he said, what's left out of the state statement is that as a de facto proposition, water rights accounting by the administrative agency of the state with the authority to administer water rights can, as a practical matter, define water rights. That's the problem. You can't let the tail wag the dog. So returning back to my outline, after having hopefully addressed to your satisfaction questions you raised in the earlier appeal. You heard
somewhere along there, and I don't care when, talk to me about Rule 60B, okay?
Well, I'll do it right now.
All right.
I will get to it a little deeper in the presentation, but just briefly as a preview. The fact of the matter is, Judge Wildman's decision below was res judicata based, and then an alternative decision rebuking Special Master Booth for reaching the merits and saying he lacked jurisdiction and authority, which means the SRBA court somehow lacked jurisdiction and authority. And so frankly, I have a problem with Presiding Judge Wildman suggesting a Rule 60B vehicle in the SRBA court, only to say, in the bigger picture scheme of things, in the context of our prior arguments, you don't have jurisdiction here. Can't have it both ways. I'll get into that a little bit later. And frankly, Rule 60B is not the exclusive vehicle either. The SRBA was still ongoing. These late claims were granted within the window of the ongoing SRBA, and I will get to it later. That set in motion mandatory statutory obligations that neither the court nor the director of the department can narrowly tailor. But in getting back to reservoir operations, you heard this morning the spill and fill operations. It's elegant in its simplicity and in its safety. You spill water to create and maintain open space early in the season so that you can safely capture and fill in with the reservoirs with flood flows, peak flood flows, so as not to cause downstream property damage. Those operations began in the Payette Basin in 1957. They continue to this day, and they will continue for so long as those dams exist, pursuant to congressional authorization, pursuant to federal law, and pursuant to this state's common law, the duties owed by dam operators. What is in dispute is not the operations. Those aren't going to change, and those are going to continue. But rather, what is in dispute is whether the existing storage rights that were developed, licensed, and adjudicated contemporaneous with the advent of that operational regime were somehow licensed, claimed, and adjudicated ignorant of it. Those very smart people decades ago who came up with this system and claimed the water rights accordingly could not have possibly missed that boat. And that includes former directors of the Idaho Department of Reclamation. So the state in Suez's position is that flood control releases constitute the storage and use of water under the existing storage rights. That the water passing by the water user's head gates in January through May, when they cannot by law divert it because of the restrictive period of use, or they have no need for it because their natural flow rights remain in priority, is their water. That water that cannot be stored and used is stored and used under the existing storage rights, and that the water that can be safely stored and used later is not. This necessarily means, and the state's not shy about it, that millions of acre-feet of water over the past 60-plus years in the Payette Basin of post-flood control release capture and beneficial use occurs without the security of a water right. That it occurs according to administrative whim, the policy of maximum beneficial use, and not under a secure property right. Forgive me for being a little staccato, but I think that's insane. The district's position is that flood control releases do not constitute the storage and use of the existing storage rights. That the water that can safely be stored for future use is stored and used under the existing storage rights. You look at the partial decrees for these storage water rights, and there is nothing contained on the face of them that precludes this manner of fill and spill operations. The safe filling of the reservoirs after regulating peak flood flows. Likewise, there is nothing on the face of them that supports the state's position that you must, as a requirement of these rights, command all river flows in priority and store as quickly and early as possible. Water rights contain certain benchmark elements that we've all come to rely upon, but those elements do not finitely dictate the diversion and use of water under all circumstances. If they did, they wouldn't be 1- and 2-page documents. They'd be 50 to 100-page books. They do not dictate the means of conveyance. You're free to use a pipe or an open ditch. Do not dictate the means of irrigation, whether you choose to flood irrigate, sprinkler irrigate, or drip irrigate. They do not dictate the crop to be grown, and they do not dictate within the season of use or even the upper limit of quantity how much must be diverted and used at any given time. Rather, Idaho law is clear that judgment and discretion rests with the water user. And what better way under these storage rights that contain no restriction in this regard than to use that discretion to safeguard property and life downstream of these facilities. Don't get wrapped around the axle of res judicata and its potential application in this case, because that application or that concept or doctrine does not apply to an examination and evaluation of the existing water rights. In the alternative, if this court does find there's a deficiency in the existing storage rights, then res judicata does not bar the judicial recognition through the late claims process of the constitutional method water rights that exist as a consequence of these fill and spill operations. Nobody here before you is going to dispute the fact that prior to 1971, flood control years, these facilities were operated on a fill and spill basis. That necessarily begets some block of second-in water captured, stored, and used after flood control releases that was ultimately beneficially used. That is a constitutional method water right, whether you like it or not, under mere diversion and use. The state itself concedes that there was no method of water rights administration to protect or object to during the pendency of the paid adjudication. Exactly. So far as everybody was concerned, it was a physical contents-based system that operated on a fill and spill basis, and nobody was none the wiser. Arguably that changed in 1992-93, but Chief Justice Burdick, I think I answered your question that really there is no water right, this is permissive storage that will let you do. That didn't happen until the late 2000s and then was at issue in Basin White Issue 17. Although unfortunately in that situation, the question was framed in such a way by the presiding judge to evade the question. According to the state, there is no water legally available for junior appropriators as long as the decreed water rights remain in priority. And that in turn would mean flood control decisions become the basis for determining whether water rights are legally available. That is wrong. You heard that flood control is dependent on the release and pass-through of water, not the withholding of water from the system to the exclusion of others. Over a century of Idaho precedent, the Watson-Hutchinson Slough Ditch case from 1909 tells you that the water passing by a senior headgate, undiverted and unused, or in this case through a dam, is treated as unappropriated water available for use by others. That is what you'll hear in Basin 63 as well as what happens in Basin 63. Suez is very familiar with this. They have water rights with conditions within them that say you get to divert and use when they're spilling. It's that simple. That can be done upstream or downstream of these facilities. So what are the potential consequences of the state and Suez's positions? First, we can't be left without a property right. Director whim and administrative policy could change tomorrow. Who knows, maybe next summer they say, no, you actually don't have a water right, therefore we're going to enjoin the Bureau, or rather, instead of going after the Bureau, go after the water users and enjoin the water users from opening their headgates and diverting that storage water that the Bureau captured as a flood control operation. Upsetting the finality and security of the existing storage rights exposes them to claims from third parties, maybe even downstream states. That weakens, that doesn't strengthen state control over its water resources. Upsetting the finality and security of these storage rights jeopardizes the flow augmentation provisions of the landmark Nez Perce Agreement. Flow augmentation relies upon these existing senior storage rights and the rental pools that they support. Upsetting the finality and security of these existing storage rights weakens the position of the water users vis-a-vis the Bureau. Our contractual entitlements to delivery and our contractual ownership and space in these facilities is rooted in these water rights. If these existing storage rights are undermined, then so is our ability through contractual obligation to keep a thumb on the Bureau. We are undoing what the water users in this court accomplished in 2007 in the Pioneer decision. And finally, if the state is allowed to leverage silence within the elements of the existing water rights, you heard this morning, finality, finality, finality. If the state is allowed to leverage silence and inject terms that do not otherwise exist and dictate ultimate methods and use of water under these rights, what is to stop it under the guise of administration or maximum use policy to do the same to anybody? That's because our...
You have run the water system in Idaho, Mr. Waldera.
You can run the water system in Idaho, But this court has repeatedly said you do it according to the law.
Okay.
And those
The
elements
legislature has passed.
and our fill and spill operations,
Therefore, it is certainly not unfettered, is it?
it's not. That's why we're here.
Correct.
But the point is, if the state can read into these existing storage rights, terms that don't otherwise exist, that you must capture and store this water as early and quickly as possible, you don't find that in these decrees. They can take that position with any number of other decrees in this state.
Since 1993, have you changed your water usage to that system?
To the system being...
That you just said, that we must
No.
capture everything immediately.
No, and we can't. And that's why it's absurd to think that these operations operate outside of the water rights that support them. Federal law, congressional authorization, and state law duties will continue to require that these reservoirs be operated this way. To think that the water rights don't also operate in complement with those operations, that's flabbergasting. My clients need secure property rights. They don't need permissive, fully subordinated storage. Permissive, fully subordinated storage is not a water right. It is not a line in the sand that we can defend. And it is contrary to Idaho law. And decades of water use and development and investment cannot be left to chance. And finally, I'll close. I realize I'm running over, but that's all right. I'll close with the fact that SRBA court jurisdiction in this matter was proper. The state tells you the accounting program doesn't create, define, or alter water rights. Who does? The courts. The SRBA court is the first cut. Then we come to you guys and gals. The accounting program in and of itself, as a de jure proposition, is of no independent legal import. But as a practical matter, what you're going to see in January is the backfilling of legal theory to try and support that program in a manner that takes these water rights. The question of what to count is not the same as how to count. This court teased out that distinction in its Basin-wide Issue 17 decision in 2014. Is the director determining property rights, or is he merely distributing the water? And this is not a water distribution case. While the department would like to account and track water flows year-round, that's fine. That is its prerogative. We don't dispute that. But you cannot use that program in a manner that imperils these underlying water rights. This is also not a distribution case under Title 42, Chapter 6, because this is not a scarcity of water problem. This is a too much water problem. Nobody is divested of use at all. Again, flood control releases are dependent on flow through, not the withholding of water from the system. Presiding judge offered the Rule 60B option. The answer might be different. It might not. It's a pretty high bar. And why would anybody have any supposition or justification to file that motion when the late claims were an alternative, viable, live vehicle for addressing this matter in a few different basins at one time?
Are you aware of any 60B motions being granted in the context of an objected to case?
I am not. Not on that specific fact pattern. What I am aware of are a couple of recent Rule 60B motions that have been filed that have been denied.
They have been denied?
Denied. So, but outside of that, with that nuance of yours, I apologize, I'm not. But let's refocus how this all surfaced. The same motion for late claims was filed in multiple basins on the same memorandum in support. The court granted those motions. It set in motion mandatory statutory processes under 42-1409 through 1413. We, Black Canyon, said this is nuts. Those late claims are suggesting that the existing storage rights we depend on aren't what they are. We were obligated to come forward with evidence and argument to support our position. This is not an administrative proceeding. This did not originate as an administrative proceeding. And while the district judge, perhaps in hindsight, would have preferred maybe not to have granted them, He did. And those statutes are clear. The nature and scope of the proceedings are what they are, and you proceed accordingly. The presiding judge and the and the director do not get to narrow those proceedings. And even for the sake of argument, if these proceedings could be narrowly tailored, Special Master Booth, early on in the context of a motion for reconsideration seeking to change his grant of intervention to Black Canyon, he said in response to the state, how could I possibly, through a late claims proceeding, determine whether constitutional method water rights exist, whether there's been the diversion and use of additional water, unless and until I figure out where the existing water rights leave off? Pretty logical. And I sensed collateral attack concerns. I think Justice Burdick, you didn't use the terms collateral attack, but you said, you know, are you working within the water rights, outside the water rights?
Seem to be getting a lot of those.
1.3 million acre feet. Wait a minute, what's going on here? Well, no, that's why
I have a distrust of giving the United States 1.2 million acre feet is all, and that was the reason for that question.
But that's subject to rule curve-based spill and fill operations. Those aren't going to change. So you're secure that this is pass-through water. But furthermore, Black Canyon's arguments work within your concern. We are seizing on the beneficial use of water, the 863,000 acre feet of water that we were licensed and decreed twice over and have used since being licensed.
So you've not in any way lost any water right under this accounting system, correct?
Not unless you uphold it by upholding the law that the department argues in support of it. The department is attaching legal import to this program. And if you buy in to their legal argument,
saying you have your water right and it's decreed and that's all you get. That's what I heard them say.
And that's all we need, provided you don't have to.
But you've not been damaged by this system that's been going on since '93, have you?
We haven't until now. If you uphold the state's position and what you hear in January, because all of a sudden we don't have a water right. It's permissive storage.
I understand that we've got an adjudicative administrative issue coming down the pike. I'm dealing with late claims here. Cataloging of water rights versus an administration of water rights.
Agreed. And the state tells you in its briefing in this case that the storage is permissive. Suez tells you it's ancillary. You're right. You don't have a water right. We agree with the state. But because you have underlying water rights, you somehow have this ancillary use to excess flows. That's not a water right. That's more akin to a general provision. And we can't have that. And this is not a collateral attack furthermore. If the late claims must go forward because you disagree with me on the existing storage rights, then the late claims go forward, they leave the elements of the existing storage rights completely intact, and we go our merry way. There is no collateral attack in this case. Thank you.
Oh, thank you. Sorry.
I think you can feel free to stand up, Mr. Orr.
Oh, I'm sorry. I'm old. If I don't write it down, it's not going to be remembered.
I have to do this. I have to do the same thing, Your Honor.
I'm sorry.
I just didn't want to be presumptuous. Again, may it please the court, Michael Orr.
Thanks for the help, though.
Anytime, boss.
Michael Orr for the state of Idaho. And I'll just start by saying there's a lot to respond to there, and I'll do my best. But I'll begin by saying, Justice Burdick, I think your point was correct. These cases arise, this appeal arises out of two SRBA claims for beneficial use-based water rights. Beneficial use asserted to have taken place in 1965. But Black Canyon doesn't want to talk about that. All of the arguments in this appeal reduce to one of two things. It's either a challenge to how IDWR accounts for the distribution of water to those rights, or it's assertions about what the existing water right decrees, how the existing water right decrees should be interpreted. specifically that they should be interpreted as including entitlements or elements or administrative provisions that they clearly do not, and that the Payette decree also clearly did not. And that brings us back to the cases I mentioned earlier in the previous appeal, Basin-wide 17, AFRD 2, City of Blackfoot, the Igwa and Rangan cases. I think those are controlling here. Now they apply here because the argument basically is that IDWR's accounting system is contrary to prior appropriation and that the United States water rights must be interpreted as endowing the United States with priority rights to command the entire flow of the river. That was the basis for the quantity element that they've asserted. They want all the water in order to make all juniors and all future appropriators subject and subordinate to the United States flood control decisions. But under this court's decisions, you don't use late claims, you don't use SRBA claims for new water rights as vehicles for challenging IDWR's administration to water rights that have already been decreed. And the interpretation, the United States interpretation of the partial decrees is a collateral attack, Black Canyon's rather, because it's asserting the partial decrees include things they clearly do not. And again, I want to reemphasize this last point is particularly important here because finality in a general stream adjudication is absolutely essential. This court's repeatedly recognized that. And the arguments we've heard today would undermine the finality of the SRBA and any other past, present, or future water rights adjudication. The holder of a water right decree could reopen a completed adjudication by simply alleging that IDWR should be administering the water rights according to historic operations or practices that were never claimed or decreed. And in this case, accepting the interpretation of the partial decrees and the Payette decree that's been put forward would replace priority administration under Idaho's prior appropriation doctrine with flood control-based administration governed by federal law. It would put federal reservoir operators in control of the use, distribution, and development of Idaho's water. Now, the argument that, the basic thrust of the argument, as I understand Black Canyon's about the nature of the existing rights, is that they already appropriated the water that's been claimed. This is a collateral attack. As we pointed out in the table on page 31 of our brief, all you have to do to determine the nature and extent of the existing rights, where they end, as it were, is to look at what was decreed. And then you compare it to what's on the face of the lake claims. We didn't need to go into the very deep inquisition of the accounting system or flood control operations to get at that. It's just on the face of the lake claims in the decree. You compare them. The lake claims claim more water. That's a collateral attack because the argument that's made is that was already decreed, and it clearly was not. As this court recognized in Basin-wide 17, the partial decrees define rights, quote, to a certain amount of water. A number the director must fill in priority, and they don't have priority refill remarks. Partial decrees do not authorize or provide for administration based on concepts such as single physical fill or, quote, maximum physical fill or, quote, spill and fill operations, or based on rule curves or federal runoff forecasts, or based on identifying flows that Black Canyon vaguely describes as the, quote, last in water, or the second in water, or the so-called peak flows, whatever they are. And the fact that Black Canyon has no difficulty arguing here that such terms and concepts are integral to the definition and administration of the water rights previously decreed in the SRBA and in Payette adjudication simply shows that the same arguments easily could have and should have been made in those adjudications. As the district court said, it should not have been an arcane proposition to seek administrative provisions in the decrees memorializing views on the nature and extent of the rights with respect to flood control operations. Now, Black Canyon's alternative argument that the lake claims were an appropriate vehicle to reopen or revisit the partial decrees, again, that's contrary to the purposes of Rule 60B and would render it superfluous in a water right adjudication. Under that theory, the requirements of the rule could be circumvented by the simple expedient of seeking permission to file a lake claim for a new water right and then pivoting towards an existing decreed water right once that permission is granted. And that, in a nutshell, is exactly what happened in this case. But accepting this type of argument would undermine the finality of the SRBA by opening partial decrees to collateral tax in lake claim proceedings. Now, Black Canyon's alternative contention that the district court always understood that the real purpose of the lake claims was to reopen or revisit the rights, it's contrary to the record. It's just revisionism. As we discussed in our brief, the record shows there are absolutely no such representations made in briefing or oral argument when the United States and various other parties sought permission to file the lake claims. And if there had been adequate notice that this was the true purpose of the lake claims, the state would have objected, just like we objected to one of the claims filed by the Surface Water Coalition in that very same hearing. As we discussed in our brief, the Surface Water Coalition asked for permission to file a refill lake claim to bring a previously decreed water right back into the SRBA in order to resolve a disputed question of administration of that right. The United States, or the state, objected to that claim, and the district court ultimately denied permission to file it. That was discussed in our briefing, which includes supporting record citations, and we attached a copy of the district court's order denying that lake claim as an addendum to our brief. And this was all done at the same time. This was part and parcel of the United States lake claims. Same motion, same motions, same hearing. And as the district court also said, quote, "It needs to be emphasized that leave was granted for the filing of beneficial use claims that were separate and distinct from the previously decreed water rights." That's on page 6 of the Basin 63 lake claims order that the United States included in the addendum attached to the brief in its appeal. The question of whether to grant the lake claims was discretionary. The district court did not abuse its discretion by expressly limiting the lake claims to the express purposes for which they were filed. In addition, the district court did not refer the previously decreed water rights to the special master. And as a matter of fact, the district court had entered the final unified decree 5 months before referring the lake claims to the special master. Final unified decree expressly incorporated the partial decrees that had previously been issued, provided they were conclusive as to the nature and extent of the rights, and were binding for purposes of administration. The district court did not retain jurisdiction over the previously decreed water rights in the order regarding subcases pending upon entry of final unified decree, which was filed at the same time as the final unified decree. And the final unified decree retained jurisdiction over the previously decreed water rights only for purposes of considering matters that are not reviewable under the Idaho Administrative Procedures Act. And it is undisputed that Black Canyon's objections to how IDWR interprets or administers the decreed water rights are reviewable under the Administrative Procedures Act. And under this court's Basin-wide 17 decision, Black Canyon must present its accounting objections to the director first and must seek judicial review pursuant to the Idaho Administrative Procedures Act rather than filing an SRBA lake claim based on beneficial use. Now, with respect to a couple of issues raised here, Your Honors, I believe I heard quite a bit of argument about the nature of federal flood control operations, a lot of detail, a lot of assertions about how it's done, what's passed through, what's stored, what's not. We don't have the record on that. That's just argument that's offered in this appeal. We only have in the record some very general representations about the general nature of federal flood control operations and how or if there's any relationship to the accounting system. In order to evaluate Black Canyon's objections to the accounting system, we need a fully developed record that actually addresses all these things and tells us what's actually going on rather than relying on argumentative characterizations of the accounting system and flood control operations here. We don't have the record, and we, to the extent those issues have been raised in the Basin 63 cases, and they have, what you're hearing, what you've heard here basically is a lot of excerpts of the briefing submitted in those cases. Those issues will be decided in due course. And again, if Black Canyon or the United States decides that based on that decision, they need to or should be objecting to the Basin 65 accounting system, they can still do that. But this case in no way depends upon that. This is a late claims case. The issues before the court are preclusion and jurisdiction only. And affirming the district court, which we believe you should, it will in no way cut off the opportunity of Black Canyon or the United States to seek redress for whatever it believes is objectionable about the accounting system. Now, I also heard counsel go into quite a bit of detail about what happened in the pay-ad adjudication, even going back to the original water right licenses, the pay-ad claims, the proposed finding that was incorporated into the pay-ad decree. And those things say what they say, and I will point out the licenses strictly limit the amount of water to the volume applied to beneficial use, and no larger than 700,000 at Cascade, and I think 163,000 at Deadwood under any circumstances. But all that being said, all these arguments about what the pay-ad decree actually adjudicated, what it did not about flood control operations, could have and should have been raised in the SRBA when the United States filed claims based on the pay-ad decree. And the accounting system had been in place for a number of years before that. There's nothing they didn't know about the accounting system at that time. So I want to try to wrap up here, and I'm looking for my last page. Well, I guess I heard again the argument that something changed. There was some kind of big change in '93. We didn't know about it. We couldn't have anticipated it, and it justifies everything we're arguing here today. There was no change. In 1993, IDWR started administering water rights in the pay-ad decree according to that decree. The pay-ad decree did not change. Idaho's prior appropriation principles did not change. And I believe I've even heard some admissions from counsel that the accounting system didn't change anything either. As a matter of law, it couldn't. So to the extent that accounting system is a basis of their arguments here, it's not properly addressed in this proceeding or through a beneficial use-based late claim. And to close, I guess I'll say that I've heard repeatedly that admissions, I believe, that there has been no beneficial use of the water, the additional water actually claimed in the late claims. The assertions that have been made is that it's simply passed through, nobody uses it. That may or may not be true, but if that's true, then what are they claiming? If the existing water rights already cover what they're claiming here, why were these claims, why were they even filed? I would submit that clearly they are claiming something over and above what was originally decreed. So that, in the form of a collateral attack on those rights.
Well, but aren't they saying we just did that out of an abundance of caution? I mean, they're saying we shouldn't have to file.
And if that is the case, if the water rights do actually decree what they say, what they mean, what they say it means, and what they're disagreeing with is the administration of those rights. And that's not an SRBA question. It's not a lake claims question. It's not a beneficial use question. It's a question about water management. It's telling the director, you're doing it wrong. Here's what our decree says. There's a way to address that. And lake claims in the SRBA, especially based on beneficial use that predated all of this, is not a vehicle for challenging, for raising those types of issues or objections. So I guess I'm done, Your Honors. I'll stand for any questions. See, I have a little bit of time left, but I think I got through my list.
Thank you.
Thank you.
Sorry, thanks again, Mr. Moore. Mr. Lawrence?
May it please the court, good morning again for the second time. I will try to be brief. First, I want to point out that the vast majority of Mr. Waldera's presentation today underscores why Suez is here in Basin 65, because he's talking about what already decreed rights mean, or what the accounting system means, or what will happen or may happen in the Water District 63 accounting case. That was Suez's concern, is that issues relevant to Suez and its interests in Basin 63 are going to be raised and argued and litigated and possibly determined in a different proceeding, a non-Basin 63 proceeding. So that's why we're here. Wanted to follow up on this idea that's been talked about a lot this morning, whether anything changed in the 90s when the department implemented administration. And I agree with Mr. Orr, there was no change. There was simply administration where there had not been administration before. And I don't think that Idaho water law countenances a right to be free from administration of your water rights. And the advent of administration should have come as no surprise to anyone, particularly the claimant, the federal government in this case, who has reservoirs and water rights around the state, including reservoirs and water rights being administered at that time that were already being administered up in the Upper Snake according to the same principles that we're talking about here in Basin 65, Basin 63. So it should have come as no surprise. They knew administration, or they should have known administration was coming down the pike, and their eyes should have been fully wide open as to what that administration was going to look like. It is already going on with respect to their water rights elsewhere. I'd also like to add that there's arguments been made this morning that somehow this method of administration is out of left field. How can the department possibly be doing something so crazy or unconventional? It's not unconventional whatsoever. It follows from fundamental prior appropriation principles. We briefed this in this case, Basin 63. Frankly, we see no other method of administration under prior appropriation that will give effect to the elements of the decreed rights, that will not injure other water users, and that will further the policy of maximum use in the state. The existing decrees, which Mr. Waldera spent the majority of his presentation discussing what they mean, of course, what those decrees mean, that's not at issue here. Those were decreed more than a decade ago, and the nature and extent of those rights should have been resolved then. But nevertheless, we heard a lot of argument about that today. And Mr. Waldera suggested that the state and Suez are looking at silence in the decrees and reading certain terms into them. By the same notion, Mr. Waldera is reading a term that's not in the decree, this ability to refill in priority after flood control, not stated on any decree. Those decrees, if you look at the face of them, they allow storage for beneficial uses. They don't say except when flood control happens. It says this amount, this volume of water stored for beneficial use. And this premise that these existing decrees should not be considered satisfied until the federal government says so, until they're done with their flood control operations, that can't square with the elements of the water right that don't allow for flood control, that don't allow for second fill, expressly on the face of the rights, or the quantity elements. Water is simply not merely bypassed, just flowed through X quantity in, X quantity out. The federal government frequently, and this year is a good example. I just looked on the Bureau's Hydromet website yesterday and saw the graph of the Payette system, where they stored and then evacuated during the spring. After storing X amount of water, they evacuated more than 100,000 acre feet. So that was water that was stored. They released it. Then they stored it again. They stored water twice, and they want the ability to do that under priority. If they store water twice, they will exceed the quantity element. Under priority, they will exceed the quantity element of the water right. That's why they never grapple with this. They just say, well, we should just count how much water is in the reservoir at the end of when we reach maximum fill, and we'll tell you when we're there. Well, they can fill and spill and fill and spill and fill and spill again, and that's a vague and fluctuating quantity. We don't know what that's going to be at the end. But if they store once, release, and store it again, we know it's going to exceed the quantity element.
But, I mean, we've got flood control, it seems to me, is in every person in this room's interest. Every person. And it seems to me that there's a tension in the system between how do you deal with the very real risk posed by reservoirs, which is if we hold them to maximum capacity, we may end up with a salmon dam situation with everybody down below flooded if we don't handle it right. And so then what do you do with the fact that your flood control might end up in a shortage situation, and how do you share the risk of the shortage of water at that point in time? I mean, that's what this is all about. It's about who bears the risk of the shortage when you engage in an absolutely legitimate purpose of controlling floodwater.
That is a good point, Justice Brody, and no one that I know of is saying stop flood control operations.
But that's an, well, I don't want to argue.
This what we're talking about fundamentally is priority.
Right, but who bears?
And
all of us.
Well, I'll try to answer your question because I've thought about this. We've talked about this a lot. This is the tension. You've hit the nail on the head. This is the tension. In this case particularly, it's the federal government that's twisting the knobs and pulling the levers and deciding how much water to release for flood control. Well, it's not the state of Idaho. It's not downstream water users. It's nobody else. And the tension, the incentive to keep as much water back, not release more than necessary for flood control, that is created by limiting their priority to the quantity of the storage rights. If that quantity can fluctuate, optimum flood control operations would leave the reservoirs empty because we don't know how much is going to come, so we want the ability to catch it all. Idaho water law, storage water rights, storage for beneficial use, the purpose is to store the water. We want them to store as much water as possible. This is a prior appropriation case. This isn't a flood control case. Yes, there are obligations for flood control on Idaho law, but this is a prior appropriation case. We have decrees that don't have, if the United States wanted to seek flood control authorization, they should have had it decreed in their rights. They should have had that purpose of use. They should have had a remark. But they don't. These are storage water rights, the purpose of which is to store water for beneficial use. That's why the day after the irrigation season ends, they start storing water. They don't know. They want to store as much as they can. They don't wait. They want to store as much water as possible. That's the purpose of those rights.
I want to make sure the record is clear about one thing, though. You mentioned it's the federal government pulling the knobs and levers. This is about Idaho water users, right? I mean, the beneficial users of the water in Cascade and the Deadwood are Idaho people and Idaho growers and Idaho municipalities. It's not about the federal government.
You are absolutely correct that the end users of the water in these reservoirs are Idahoans. And they have contractual rights with the federal government to use that water. And if the federal government somehow fails in their obligations to supply that water because they twist their knobs and turn their valves incorrectly, that's a different case. That's not the case we have here. What we have here is the federal government who does a really good job of this. And even since '93, since the accounting system has been in place, they've done a really good job of managing the reservoirs and still filling them and satisfying their users. So the systems work. The system works. It's not broken. And it works because of these fundamental principles that are embedded in what's been called the accounting system, but it's really, the accounting system is just it's a fancy spreadsheet. It's an abacus. It's just counting the beans. It's the principles of how you count them. Those are embedded in prior appropriation law. Mr. Waldera mentioned that, they need a priority date. They need to secure this refill water with priority. Because if they don't, who knows what the Department of Water Resources will do. Maybe they'll change their policy. Well, we're more concerned that the federal government is going to change its policy, its reservoir operations policy. The flood control rule curves, they're not mandated. They can change. They're subject to, they in themselves are subjective. I think there's a misunderstanding by a lot of folks that they always spit out just a mathematically precise result. There's subjective assumptions that go into using those rule curves. That subjectivity is not in the hands of the department. That is, in this case, the federal government. They get, under their policies, to decide how to manage those rule curves and whether to change them. I finally would just like to mention that along those lines, this case is about Idaho water law. It's not about the federal government's operations or its laws or policies concerning reservoir operations. What does Idaho water law require? What do these storage decrees mean? And in this case, Idaho's jurisprudence concerning res judicata and the finality of adjudicated rights. I'll stand for questions. That's all I have.
Great being on. Thank you, sir. How much time does the appellant have? Sir?
Thank you. One need look no further than the original memorandum in support of the lake claims filed by the United States. The United States did not go looking for this. These lake claims, as you point out, Justice Brody, were filed as an alternative hedge, accepting the state's new rules on their face out of an abundance of caution. And in a footnote in that very memorandum, it says, if the petitioners in Basin White Issue 17 prevail, These claims are withdrawn. They are not necessary. The United States didn't believe in them either. Certainly Black Canyon doesn't believe in them, but they are absolutely necessary if we are left without the sufficient authorization under the existing storage rights to safely store and use 863,000 acre-feet of water. That was licensed, claimed, and decreed twice over. Interpretation of the existing water rights decrees is the issue in this case. How can you make a lake claims determination of where they begin if you don't figure out where the existing rights leave off? That is the issue. The rule curves, flood control. Flood control is necessarily control of the river. We all want it. They just told you it's not going to change, and we all want it. So how do you work within that framework? You mean to tell me that all those people decades ago were ignorant of these concepts and somehow said, Director of Reclamation in 1957 or 60 or 70 or 80 said, hey, wait a minute, we can't license those water rights. We can't approve those claims. These flood control operations run afoul of Idaho water law. The state government didn't do that. These rule curves are not nearly as informal as these people would lead you to believe. You look at, again, the affidavit of Gerald Gregg, and specifically record page 1817 and the following pages. When these rule curves were last refined in 1995 as part of a NEPA process that further cemented them, which were later engrafted into the Nez Perce agreement, look at the mailing list of who was invited to comment. I see Mark Limbaugh, the water master for Water District 65. He's a state official. Carl Dreher, the director of the Department of Idaho Water Resources. Dave Tuthill, then Western Region Manager, former director of the Department of Idaho Water Resources. There's no federal black box going on here. These things weren't conceived in a vacuum. The state has played a direct role in these operations and these rule curves from day one. The SRBA was wrapping up. The late claims were deemed necessary. Would you have missed that filing deadline? Would you have not argued as we did?
Well, thank you, Mr. Waldman. Matter is now under advisement and we render decision.